The Departments of State and Homeland Security both have responsibility when it comes to admitting foreign visitors to the United States. Departments of State, Consular Affairs is responsible for issuing visas, while Immigration and Customs Enforcement and DHS operates the visa security program in designated high-risk consular posts overseas. Following the tragic events of September the 11th, 2001, there was a great deal of discussion in Congress with respect to moving the visa issuance responsibilities from the State Department to DHS. The objective to treat visa issuance as a law enforcement and national security function rather than a foreign relations tool. Rather than transferring these functions to DHS in their entirety, the Homeland Security Act of 2002 split the visa functions. DHS now writes the regulations regarding visa issuance and assigns staff to consular posts abroad as part of the visa security program to conduct investigations on visa applications. However, the State Department still has a responsibility to ultimately issue the visas. Unfortunately, the visa security program has not expanded nearly as quickly as expected. The Government Accountability Office reports that ICE has now implemented its 5-year expansion plan, has not implemented its 5-year expansion plan, or even covered all high-risk posts. Therefore, Chairman Smith has introduced legislation, the Secure Visas Act, that requires DHS to maintain visa security units, known as VSU, at the 19 consular posts that already have them, and expand these units to the posts that ICE has designated as high risk. Some of the high risk countries include Yemen, Saudi Arabia, Syria, Morocco, Lebanon, and Algeria. VSUs are critical for national security. At VSU staffed consular posts, 100% of applicants receive additional screening. At non-VSU posts, fewer than 2% of the applicants get extra screening. The actions of Umar Farouk Abdul Muttalib, is that close enough? Okay. Who attempted to blow up Northwest Airlines Flight 253 and kill over 200 innocent people on December 25, 2009, refocused attention on the responsibilities of the Departments of State and Homeland Security with respect to visa revocation.
Thank you, Chairman Gallagher and Vice Chair and Ranking Member Lofgren, for the opportunity to testify today on the importance of assuring that security is embedded throughout the visa process. Let me start today with my conclusion. Extending appropriate visa adjudication authorities judiciously where necessary helps build a stronger and more flexible border framework that can adapt to changes in terrorist travel methods as we move forward. The 9/11 Commission recommendations emphasize that terrorists are best stopped when, quote, they move through defined channels, end quote. Remember that of 23 hijacker applications, 22 were approved. The first and best opportunity to stop terrorist travel is in the visa adjudication process, where triggers for further investigation can mimic what should have been triggers in the 9/11 investigation, such as recently obtained new passports, suspicious or fraudulent travel stamps, indicators of extremism, or incomplete applications or fraudulent applications. However, we know that new terrorist travel methods evolve constantly, and it is actually DHS and ICE that have the best access to the information and expertise to expose those methods, because only ICE holds that open case information and sensitive data we need to identify terrorists. In addition, and this is really important to our discussion today, a foreign national's affiliation with terrorism may develop after or because of an already existing U.S. visa. Osama bin Laden and colleague Sheikh Mohammed specifically sought out individuals with existing U.S. visas. Thus, in my view, visas need periodic review, especially prior to U.S.-bound travel. Revocation investigations need to be as robust as those conducted by VSUs prior to visa issuance. In fact, as we know already, visa revocations can be the linchpin to deny entry or support removal of those already in the United States. With the death of bin Laden and an increase in retaliatory statements by al-Qaeda, we may now experience even more splintering of al-Qaeda into factions or lone wolf type terrorists. Our consular posts will be under more pressure than ever to get adjudications right, most particularly in visa-issuing countries where there is currently no formal policy on pre-travel vetting. Today, visa waiver travelers coming for business or pleasure are vetted through ESTA, a DHS travel authorization program which operates as a virtual mini visa for nationals of visa waiver countries. But visa issuing countries have no such standardized pre-travel vetting. This is a significant gap, even if State Department is trying to fill it in right now. There's no formalization of that. In these instances, revocations could occur without the threat posed by airline travel of a terrorist such as the Christmas Day bomber. From the lens of a former 9/11 Commission staffer, my view is that extending visa revocation authority to DHS and expanding VSUs worldwide is common sense from a legal, policy, and bureaucratic viewpoint. VSP security-related reviews in high-risk areas of the world and throughout the visa process are essential. From a policy perspective, security has to trump infrastructure, political, or diplomatic considerations that are not always in line with security decisions. From a legal perspective, it is DHS that is responsible for both homeland and border security at heart. Thus, what VSUs add to security of visa processing at consulates overseas is invaluable because it's what they do. The State Department has its top mission as diplomacy, and it's absolutely vital and necessary function, and the work they do is extremely important. But the state's chief of missions really shouldn't have a say in determining whether VSU presence should be at a consular post or not. Moreover, expanding VSP authority to security-related revocations is feasible. The VSU's combined intelligence, operation, and law enforcement to intercept terrorists and constrain terrorist mobility, as we've already heard today. Our national security depends in part on the robustness of our border security to keep out foreign nationals with nefarious intentions. Counterterrorism efforts outside of our physical borders and throughout the entire visa process in both issuance and revocation has to be as secure as possible. The entity really with the mission, expertise, and bureaucratic functioning on national security-related immigration cases is DHS. In addition, DHS already has that visa authority by law and issuance. An extension of that authority simply to include revocations seems to make common sense. And, legislation supporting this end should certainly be considered and a priority. Thank you.
Ms. Kephart, in your opinion, should aliens whose visas are revoked on terror or national security grounds be allowed to access the federal courts to appeal the revocation?
When you're dealing with national security cases, you're dealing with national security information. The issue is a long-standing one. This is the same issue that the National Security Unit at the Legacy Immigration and Naturalization Service dealt with, too, in cases pertaining to those currently in the United States we were seeking removal of, and the national security information there. I don't think it's ever a good idea to put, number one, state's authority to issue a visa at stake. It is a discretionary issue. The courts have decided this again and again in the circuits, and it's not up for judicial review according to 4 of our circuits. Furthermore, you're dealing with national security information, as I said, and putting that system into chaos is not a good idea from a national security perspective at all.
Thank you. I see my time has expired, but can I just add one additional question at the end? Do you think that part of this process, should they ever get into the courts, that it could force the government to release classified information that might be very important in our national security?
Right. That's what, when I was, I didn't state it clearly enough, but when I was referring to national security information,
okay,
I was referring to classified information. Yes, sir.
Thank you very much, Ms. Kephart.
We are. Ms. Kephart, do you think that the visa security program should be expanded?
Yes, absolutely. The additional positive that the VSP provides, and the DHS OIG report from 2008 makes this very clear, is that it adds a layer of on-site investigative expertise that would not otherwise exist. So you can have not only analysis of individual cases, but you can have an analysis of ongoing methods that are developing in terrorist travel. You cannot have that necessarily by simply a technology check. I agree with Ranking Member Lofgren that you need to make techs available across the board, but that technology access is only the base for an investigation. You need to have folks on board to actually conduct those investigations, and the DHS-OIG report has a very good example, anecdotal, of terrorist affiliations amongst 3 people that were only discovered because VSP was on site.
Thank you.